pretrial conference in this case. There's also 2 pending show causes. We are proceeding today by video conference. Let me ask the attorneys to place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Ron Underwood for Mr. Bowker, Your Honor.
All right, and where do we stand with Mr. Bowker's case today?
Your Honor, I've discussed this case with Ms. Brenner. Mr. Bowker is making good progress with payments, Your Honor. We believe a 60 to 90 day adjournment is appropriate. And if the court will give us a date, I will do the stipulation in order, Your Honor, with Ms. Brenner's permission.
That's correct, Your Honor. He's making really good headway with his payment efforts, so I don't have an objection to that. The show causes were for him failing to appear for previous court hearings, and I believe he needed to get his fingerprints done. I don't know if he did that or not. It looks like at the last hearing, he had pled not guilty to the show cause, but you left that in place just to make sure that he continued to show timely because he had had an issue with that in the past, and looks like he's corrected that today.
All right, we are still awaiting fingerprints. So Mr. Bowker, you need to get that taken care of. Give me the so just so you're aware, Mr. Bowker, if we get to sentencing, depending upon how this resolves, if we get to a sentencing date and I still don't have those fingerprints, my policy is to take people into custody until those fingerprints get completed. So I would advise you to do that sooner rather than later. I will grant the adjournment. $60 to 90 days would take us to around about the beginning of October. Why don't we go with October 1st at 8:15?
Sounds
Thank
good,
you, Your Honor. And as I said, I will do that stipulation in order with Ms. Brenner's permission.
Thank you, Rhonda.
Is there anything else that we need to address today?
No, Your Honor. Thank you.
All right, Mr. Bowker, so your next date is October 1st at 8:15. You're all set for today. You can go ahead and log out.
Thank you, Your Honor.
Nothing still?
Oh,
there it is.
there it is. Okay. Could you please shut the door, please? Thanks.
Okay, this is file 25-52501-P. Are you able to hear me there at the jail?
He's trying to get into, Your Honor, he's trying to get the volume on.
Volume is on.
Okay.
There.
All right, thanks.
All right, are you able to hear me, Mr. Garcia?
Yes, I am.
Okay, so this file 25-52501-PP, Kelsey Garcia versus Stephen Garcia. We are here today for arraignment on a personal protection order violation and proceeding today by video conference. Sir, you are Stephen Garcia?
Yes, correct, Your Honor. Yeah.
Mr. Garcia, here before the court today, having been arrested. So there's a complaint for violating personal protection order. That complaint alleges that you violated the personal protection order by appearing at Ms. Garcia's property on Bristol Street. The maximum possible penalty for a violation of a personal protection order is up to 93 days in jail and or a fine of $500. You do have the right to be represented by an attorney at this hearing and any other hearings we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you from the public defender's office. Do you understand that?
Yes, I do, sir. Can I state something? Can I state something?
Before you do that, I need to know, Mr. Garcia, before you do that, I need to know whether you want to be represented by an attorney.
Yes, I do. Yes, sir.
Do you have the ability do you have the ability to pay for your own attorney?
When I'm working, yes. When I work, yes, I do.
Are you working right now?
Yes, sir, Your Honor, I am. Yes.
Do you
If
have
I'm
the
about
money
to lose
right
my
now?
job,
Mr. Garcia,
you're going in and out.
listen to
sir.
the questions that I ask you and answer the questions and don't tell me about other things. Do you have the ability right now to pay for your own attorney?
Yes, Your Honor.
All right, then I can't appoint one for you from the public defender's office. What I will do is adjourn this until 1:30 p.m. And if you'd like to contact an attorney to represent you, you can do that.
Okay, yes, Your Honor. Can I get on PR, sir? So I can do that, sir? Because I want to lose my job, Your Honor. I already lost my job the first
Appreciate that,
time.
Mr. Garcia. I appreciate that, Mr. Garcia, but this is the second time you've been arrested for violating this personal protection order. So I'm not going to issue a PR bond at this time. I will issue.
Yeah, go ahead. I'm sorry.
I will issue a bond in the amount of $10,000 cash or surety.
What's that mean?
That means that you can post a cash or surety bond of $10,000.
10 grand? You're talking about $10,000, Your Honor?
No, that's not how a surety bond works.
I don't know. I don't get in trouble, Your Honor. I mean, this is all new to me, like I said. So you gotta explain to me what 10% of what? 10% of $10,000
Yes,
would be what?
that's $1,000.
Really? How am I supposed to do that if I'm not gonna go to work? I'm gonna lose my job if I don't go to work today.
Well, again, Mr. Garcia, I appreciate that, but I'm not going to argue with you, Mr. Garcia. As I said, the reason that I'm setting your bond where it is because this is the second time you've been arrested at the property that you're prevented from going to by the personal protection order. So that's the decision. We will resume at 1:30 after you've had time to call an attorney.
Okay, thank you, Your Honor. I guess, I mean, my dad wanted me over there. My dad said for me to go there so I can help him. He's 88 years old. He don't need this drama. He was here to bail me out yesterday. Adrian PD said.
Mr. Garcia, you have requested an attorney to deal with this. I don't want you to say anything further until we have your attorney present. So we are done with this hearing for now, and we will resume at 1:30 p.m.
Yes.
Ms. Underwood, will you need to speak to Ryan Delaney?
No, Your Honor.
This is file 24-21828-FH. People of the State of Michigan versus Robert Delaney. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I ask the attorneys to place their appearance on the record, beginning with Ms. Brenner?
Morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Delaney this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Delaney's case today?
I discussed this with Ms. Brenner. Mr. Delaney is making good payments. We are pleased with what he's doing. I would again ask for a 60 to 90 day adjournment, and I will again do the step in order with Ms. Brenner's permission.
Your Honor, our goal with this one is he's really close to the halfway point to do an attempt plea with a delay. He's about $2,000 away. So giving him a little bit more time, he should be able to meet that point, and then we can resolve it with a delay to give him time to pay the remaining balance down.
All right, and I apologize, Mr. Delaney. I started the hearing. I thought you had been brought into the Zoom session, but I had not clicked to bring you in yet. So I do think under those circumstances that an adjournment would be appropriate. Why don't we go with the the October 1st date that we used on the last one, so October 1st at 8:15.
Thank you, Your Honor.
Yes.
So Mr. Delaney, your next date will be October 1st at 8:15, and you can log in using all the same Zoom information that you used today.
Thank you.
Okay, so you're all set. You can log out.
Awesome. All right. Bye. Thanks.
Okay, Mr. Mawad, are you ready to proceed with Mr. Castillo?
Yes, Your Honor.
Okay. This is file 25-22269-FH, People of the State of Michigan versus Enrique Manuel Castillo. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Brenner?
Your Honor, Sarah Brenner, Assistant Attorney General for the People.
Your Honor, Elias Muwad appearing on behalf of Mr. Castillo, who is on Zoom.
All right, and Mr. Mawad, where do we stand with Mr. Castillo's case today?
So Ms. Brenner, and the court, I think, know that possibly that Enrique did pay the child support. However, Ms. Brenner, he owes some more money, right? We were just trying to figure out what else he owes so he can pay that off.
I'm still seeing a balance of over $23,000. So
Okay.
I'm not sure if there's bond money sitting there we need to move or what's going on, but I see a balance of $23,256.
Okay, there is bond money that he paid, and Enrique, what did he pay? I forget, $17,000?
15,000.
15,000, okay.
Okay, so we'll need to get that moved over, and he has a continuing obligation of $851 a month, which he needs to be meeting. So, Your Honor, I would ask that you order that the bond money be transferred over to the front of the court. I can prepare an order to that effect. And
No
then,
objection.
is it 15,000 even?
Enrique, is it
Okay.
even? Okay, yeah.
So then he would have about just over $8,000 balance left that he'd need to pay. How much time do we need to adjourn for that to happen?
Mr. Castillo, what do you think here? So now that we know the figures, so the 15 is going to go, and then you're going to have a balance a little over 8,000. What do you think?
Roughly 3 months. I was like, if I have 3 months, I can definitely get that knocked out.
Okay. So, Your Honor, I wouldn't object to an adjournment with the stipulation to move the bond. I'll remind the defendant he does need to be current with his monthly obligations during that time as well. So I would ask for that adjournment pursuant to what counsel is representing.
Okay, I will then order that the bond money be turned over to the front of the court and applied toward the outstanding child support, and we can adjourn this to October 8th at 8:15 a.m.
Judge, would you like me to do an order for that?
Yes, Mr. Mawad, if you do a stipulation and order for the adjournment, and then Ms. Brenner, if you'll do the order for the bond.
I will. Thank you, Your Honor.
And then, Mr. Castillo, are you know what your continuing obligation is, correct?
Yes, sir.
Okay, you've been a great client. I appreciate it. Thank you very much.
Okay, so Mr. Castillo, you can go ahead and log out. Your next date is October 8th. You'll log in using all the same Zoom info you used today.
Thank you.
Thank you, Judge.
See you, Sarah, unless you got another one.
I do, but thanks.
Okay. All right.
Okay, and Ms. Underwood, Mr. Gauna, I don't believe is logged into the Zoom session, and he is not here in the courtroom. I don't know if you want a minute to contact him.
I will try, Your Honor.
All right.
It's on.
Okay.
Yeah.
Is that box still in the way?
No, they moved.
All right, in the meantime, Ms. Underwood, I have Ms. Sanchez. Do you need to speak to her?
No, I don't believe so, Your Honor.
Okay. This is file 25-22308-FH. I'm sorry, 25-22308 FH, 25-22309-FH, and 25-22310-FH. People versus Betty Nicole Sanchez. We are here today for arraignment in each of those files. We are proceeding today by video conference. First, going to have the attorneys place their appearances on the record. Do we have someone from the prosecutor's office appearing on this one?
Yeah, Isaac Sneed for the people. Sorry, I'm trying to get my camera to work good.
Okay.
Rhonda Underwood from Ms. Sanchez, Your Honor.
All right, and Ms. Underwood, does Ms. Sanchez wish to have any of those informations read?
Your Honor, we would waive the reading of the information, acknowledge its receipt, and the receipt of the request for discovery and witness list, Your Honor. At this time, we would ask the court to enter a not guilty plea for Ms. Sanchez and set this for a very quick pretrial, Your Honor. I believe there is going to be a resolution in this matter. And that being said, if it's not real quick, we can always, I believe, make an appointment with the court to do a plea at another time ahead of a regular Wednesday pretrial.
So I can do July 23rd at 8:15.
Thank you, Your Honor.
So enter not guilty plea in each file for Ms. Sanchez and set pretrials in each file for July 23rd at 8:15 a.m. Okay, Ms. Sanchez, you can let the officer with you know that you are done with court for today.
Okay.
Now I will check on Mr. Garner, Your Honor.
Okay, thank you. Okay, yes. Okay, Mr. Juan, you need to speak to Mr. Knight.
Mr. Who? I'm sorry, Judge.
Mr. Knight.
Oh, no, I did want to let, if I can, before we go on record for him, Mr. Sneed, I did review some of the guidelines. With your permission, I just need a little bit more time to talk to you about it. If that's okay with you.
No objection.
Okay.
Okay, so this is file 25-22188-FH, People versus Harold Leroy Knight. We are here today for a pretrial conference in this case and proceedings by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Your Honor, Elias Muad, appearing on behalf of Mr. Knight, and Mr. Knight is on Zoom with his cat.
Sorry.
All right, Mr. Muad, where do we stand with Mr. Knight's case today then?
Judge, I know I said the last time this was going to be the last adjournment. If I could just, one more adjournment, I want to talk to Mr. Sneed about some guidelines. And I apologize, it's not anybody's fault, but a mirage of a couple trials, and Mr. Knight has been patient, and the court's been patient. Just a little bit more time, Judge, is all I'm going to need.
Okay, Mr. Sneed, anything we need to address from the people side?
No, thank you, Your Honor.
All right, let's set this then for August 6th at 8:15 a.m.
And Mr. Sneed, can I sign your name to the order, stipulated order?
Yes, please.
All right, thanks, Isaac. Thank you.
Okay, so Mr. Knight, that's August 6th at 8:15 a.m. You'll log in using all the same Zoom info that you used today.
Okay, thank you, Your Honor.
Thank
Thank
you.
you. You can go ahead and log out. Okay, Mr. Amadeo, are you ready to proceed with Mr. Olnhausen?
Yes, Your Honor.
Okay, this is file, I'm sorry. This is file 22-21196-FC. People versus Andrew Olnhausen. We are here today for a final pretrial conference. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Palop?
Good morning, Your Honor. Melissa Palop on behalf of the people.
Good morning, Your Honor. William Amadeo, P7619, on behalf of Mr. Olnhausen. We both appear via Zoom. We consent and appreciate being on Zoom. Andrew, please state your name for the court.
Andrew Olnhausen.
All right, and we're here today for a final pretrial ahead of a trial date on starting July 15th. Are we ready to proceed to trial?
Just two things, Judge. One, we do have an evidentiary hearing on Zoom tomorrow at 2:30. And we also have, I handed in voir dire a while ago. Melissa, I don't know if your jury instructions are complete or not. I usually just stipulate to the people's jury instructions if we want to stipulate to them or review them real quick. But I think we're ready as far as serving and ready to go. But I won't speak for the Attorney General.
So the people did file a list of the jury instructions. I went through it again, Your Honor, and there were just a couple that I had left off the list that go with the elements of the crimes. So I just wanted to make you aware of that, of those changes, Your Honor.
Okay, so we're gonna need those to Sierra as soon as possible because she prepares the jury instructions. So as soon as you can get those to her, and also Mr. Amadeo, obviously we need to know what the complete set is before he could agree to them.
No problem. It's just adding 20.03 and 20.09.
And the voir dire, Your Honor, was submitted by myself a while ago, and I got the people's voir dire as well. I think we have no issues with that. Again, I'll turn to Melissa on that issue, but I think we're good on that.
Yeah, I don't think there's any issues with the voir dire.
Okay. Are there any other issues that we need to address before the trial date?
The only thing, Judge, is what happens at the evidentiary hearing tomorrow could affect things, but other than that, I'm ready for trial.
I just have a couple things, and I can email Mr. Amadeo, but there are people on his witness list that I do not know who they are or what their relevance would be, so I would be asking for an offer of proof for some of them. I can submit that in an email to Mr. Amadeo, or I can state it on the record today, Your Honor.
If you want to send me an email, just I'll take the court's time up. I'll send you what you want. You have any objections, we could just talk about them more, but I'll certainly give you an offer of proof on anybody you don't know.
Okay, perfect. So I'll send that to Mr. Amadeo today. And then the only other thing is that there's another individual who'll be doing the trial. I may mispronounce his name, so I apologize for that. It's Mr. McCreary, I believe. And he just hasn't appeared or done an appearance on the case. So I just wanted to make sure that Mr. Olnhausen is voir dired prior to trial, that he, accepts Mr. McCreary as the trial attorney and has no objection. And so there's no issues moving forward with that.
Yeah, and I'll just address that briefly. Mr. McQuarrie is actually going to be first chair on the trial. He has been meeting with Mr. Olnhausen. He can send over an appearance, and Andrew will be happy to be voir dared. So there'll be no appellate issues based upon Mr. McQuarrie coming in whatsoever.
And we would just want that
All right.
voir dire on the record, but that can be done before trial. But I just wanted to make sure I brought that up, Your Honor.
All right, perhaps we can do that tomorrow and have that taken care of before the morning trial.
Sure.
That sounds good, Your Honor.
2:30.
Okay. Anything else for today then?
Not from defense. Thank you, Judge.
I don't think so, Your Honor. I think the people are all set.
And
So,
Melissa, sorry, Melissa, I'm running to another court, but if you send me that email, I'll check my phone periodically and give you that offers of proof. If there's any issues, just let me know.
Okay, sounds good.
Thank you, Judge.
all right, we will see you then tomorrow for the evidentiary.
Thanks, Judge. Have a good day.
Thank you, Your Honor.
Thank you. All right, Ms. Underwood, Mr. Gahn is in the courtroom now. Are you ready to proceed with his case?
Yes, Your Honor.
All right, so Mr. Gahn has two. He has one with the AG and one with the county prosecutor's office. Mr. Gahn, if you come forward to the podium, please. Let me start with the child support case. That is 25-22240-FH, People versus Xavier Santiago Gana. We are here today for a pretrial in that case and proceeding today partially in person and partially by Zoom. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Garner this morning on both cases, Your Honor.
Okay, and where do we stand, Ms. Underwood, with the child support case?
Your Honor, Mr. Garner is working. There's an income withholding order that recently started. So far, I think one or two payments have come out. And so we are very encouraged, and we would ask for a 60 to 90-day adjournment. And again, I will do the stipulated order with Ms. Brenner's permission.
That's correct, Your Honor. He has an income withholding order that just started, so I'm hoping that it's actually going to meet his obligation. His obligation is $702 a month. So I don't know how much he's making, but if he's not making enough to meet that, then he needs to address that with the FOC in the civil case to try to get that adjusted to match with what he's making. So, but I don't have a problem with an adjournment so we can see if he's meeting his obligation. And so then we can decide how we're going to go forward from there.
Okay.
Can I say something?
Mr. Gana, Ms. Underwood, Mr. Gana wants to address the court. Do you want him to do that?
I know, Your Honor. Mr. Garner, I know we talked, I believe it was last week. Do you want a brief breakout with me?
No, that's fine. It was just to tell them about my hours.
Oh, you can go into your hours, Mr. Garner.
Yeah, it's right now they have me at 25. They said within the next week I should be moving up to 35, maybe 40 hours. So I should be making for the month. I should be making.
Okay. So what I'll do is adjourn this to October 1st at 8:15 a.m. for a pretrial conference. And Ms. Underwood, would you do that stipulation in order?
I will, Your Honor. And yes, I will.
Okay. So we think that takes care of that one. Let's move to file 25-22240-FH, People versus Xavier Santiago Gana. Oh, I'm sorry, I read the wrong. file 25-22241-FH, People versus Xavier Santiago Guana. Here for a pretrial in this case as well. And let me ask the attorneys to place their appearance on record for this case, beginning with Mr. Sneed.
Isaac Sneed for the people.
Rhonda Underwood for Mr. Guana, Your Honor.
Okay, where are we?
would just
with
ask,
this case?
I'm sorry. We would just ask that this matter be set over to the October 1st date, Your Honor. And I will do
This
the
one was
stipulation.
bound over. This one was bound over back in April, and I don't know that I see the reason for continually adjourning this like I would in a child support case where we're trying to get payments and change the situation. So
All right, Your Honor, then perhaps set it for your next upcoming pretrial date that you have available, and we will see where we are on it, Your Honor.
So this one I'll set for August 6th at 8:15.
Thank you, Your Honor. And I will do the stip in order with Mr. Sneed's permission.
Yes.
All right, so Mr. Gani, your next date on that one is August 6th at 8:15. You can attend the pretrials if you want by Zoom instead of coming to the courthouse in person. And if you need the Zoom information, or the bailiff has, I can give that to you.
Yeah, I left my phone at work this morning. We ended up getting held up in there. We had 2 people there, so I was like so busy. When I left and we clocked out, I had to set the alarm around, so we forgot my phone.
Okay.
So I figured I'd come in person.
Okay. So you're all set for today then.
All right, thank you. Will I get a copy of it? Because I don't have an address right now to have it sent to.
Okay, is Mr. Fry here? He stepped out. Yeah, if you would mind. Paul.
Stephen Maples and the judge, please.
He's not there.
Thank you.
Okay.
Bye.
Okay, Mr. Dagger Margosian, I have Mr. Coleman on Zoom. Are you ready to proceed with this case? I should be ready. This is file 25-2241-FH, 283-FH People versus Joshua Coleman. We are here today for a pretrial conference in this case, proceeding today by video conference. We also do have a pending bond violation. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Your Honor, Michael Dagger-Margosian for Mr. Coleman.
All right, Mr. Dagger-Margosian, where do we stand with this case today?
Your Honor, Mr. Coleman has two cases. One of the cases was just recently pulled up from district court to circuit court. I don't know if you have that in front of you. I don't know if the clerks have gotten that to here.
If it were here, it would be on the docket today for arraignments.
So you just have one case then?
Yeah.
Okay. And then I'm assuming that's 25-22283.
Correct.
Okay. So what I would like to do, Your Honor, I was trying to coordinate both of these cases to be on the same day, but obviously that's not the case. So on the 283 case, we do have a resolution that I've talked with Ms. McClure about. But on the second case, I think probably what would make sense is if we could adjourn it for 1 week to get that case on the docket at the same time. And Mr. Coleman is I believe he's in a rehab facility.
It's called Spera.
Fair.
I guess that leads to another issue in that there is a bench warrant that was issued on June 26th. Mr. Coleman had been released on a PR bond to attend Dawn Farms, but tested positive on the 12th for THC and MDMA and amphetamines.
And Judge, that positive was actually on June 25th.
I'm sorry I misread that. I apologize. So on June 25th. Mr. Coase, were you aware that of Mr. Coleman being at another facility?
Judge Spera is actually part of Dawn Farms. He was directed to go to Dawn Farms. He did get out of jail on June 12th. He indicated to me that their beds were full, so he couldn't get in right away. So no, I did not have any knowledge that he actually was in treatment. So I'm not sure the date in which he went.
All right, so it sounds like he's going to be on for an arraignment next week. That's July 16th. So I'll set this one over to July 16th, and hopefully they will be together at that point. Mr. Dagger-Margosian, did you want to speak to him about the bench warrant issue? I don't know if you were aware of that or not.
Your Honor, I can speak with him. I guess maybe if the court, because he's in treatment, I guess albeit turning himself into treatment later than he was supposed to, and obviously the positive test, he is taking steps to maybe fix that. So I don't know if the court would, I think if the court would want to quash the bench warrant, but maintain the contempt for a later time to see if Mr. Coleman at this point continues to satisfy bond conditions. That would be my suggestion. I just don't want him to like get arrested while he's in rehab or something like that. I don't think it would happen, but
All right, so what I'll do is I will quash the warrant and issue an order to show cause for that positive drug test. And we'll set that for next week as well. Mr. Coast, do you need to speak to Mr. Coleman to get any information from him?
I do, Judge, if I could have a breakout with him real quick.
Okay.
Thank you.
All right, so Mr. Coleman, you'll need to log in again next week at 8:15, and you'll use all the same Zoom information that you used today.
Okay.
And I'm going to put you in a breakout session with Mr. Coast if you give me just a moment. And then Mr. Dagger Margosian, you need to speak to Mr. Gray.
no.
This is right here.
Thank you.
Yeah.
Okay, Mr. Gray, are you there?
Yeah.
Okay. Are you able to hear me, Mr. Gray? Mr. Gray, you need to move to an area where your cell reception or internet connection is better. Mr. Gray, can you hear me? All right, I'm going to move then to Mr. Maples. I'm not certain Mr. Gray is in a position where he can hear us. I know that when he speaks, I can't understand anything that's being said. Mr. Gray, if you can hear me, you need to move to an area where you have a better and more stable. I'm sorry, what was that?
Yeah, can you hear me now?
Yeah, that is better.
While we're waiting, Judge, can I have a breakout with Mr. Maples, please?
Yes. Okay, so this is file 25-22265-FH and 25-22312-FH. People versus Brandon James Gray. We are here today for a pretrial in the 265 case and an arraignment in the 312 case. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record? Mr. Sneed, are you there?
I apologize, Your Honor. I'm covering for Mr. Sneed for a second.
Oh, okay. So go ahead then, Mr. Bayoneto.
Alex Bayoneto for the people.
Your Honor, Michael Dagger goes in for Mr. Gray.
And Mr. Dagger-Margosian, does Mr. Gray wish to have the information read in the 22312 case?
No.
And how does he wish to proceed?
Your Honor, for arraignment purposes, we would plead not guilty, but we do have a resolution on both of the matters that we're prepared to enter today.
Okay, go ahead and state the terms of that resolution, and then I'll ask Mr. Bayoneto to confirm.
Your Honor, on 22265, Mr. Gray would be pleading guilty to a controlled substance possession charge, as well as the Schedule 5 possession misdemeanor, which should be the last count on that information, and then in exchange the.
Okay, what was the first one?
Controlled substance possession. So rather than the delivery manufacturer, it would be a possession for your statute.
So which count?
I don't. Well, it would. I guess it would have to be an amended information, but it's not on the original information.
Then I need the amended information. I'm also going to need, if he's going to plead, sign waiver or advice of rights forms. Do we have those?
I can sign. the.
And the plea agreement.
Okay.
So if we don't have those documents, I can set it over for another date when we do. And the next available date I have is August 6th.
That works for the people, Judge. Thank you.
Can the people submit these documents? I mean, obviously, I can't do that. So
I need to have Mr. Gray sign the advice of rights form, which he's not here to do. The new court rule says I've got to do it in writing before I take the plea. So I would
at least, okay, so we'll sign the advice rights, but at least as far as what prosecutor's office needs to, can they submit the sheet that they need to submit?
So the plea agreement he needs to sign as well, and obviously the prosecutor's office needs to submit an amended information with. So I guess let me ask Mr. Dagger-Margosian. There was a weapon charge he was pleading to. What is that?
The weapon charge would be dismissed, Your Honor. I mean, I can outline the plea. Obviously, it sounds like we can't do it today, but I could outline the plea.
Okay, so what is that then?
So on 265, it would be a guilty plea to controlled substance possession and Schedule 5 possession. And then on 312, it would be a guilty plea to, again, a controlled substance possession an OWI, and a carrying under the influence. And then the remainder of both informations would be dismissed, and there's a sentencing agreement for no upfront jail.
I'm sorry, 312 was a possession. What was the second one?
It would be counts 2, 4, and 5.
Okay. All right, as I look at the information, I don't think we need an amended information, but we do need the signed advice of rights form.
Can he give me the authority to do that?
I'm not gonna do that. I don't know if that's
understood.
I mean, the court rule says I have to present it to him. Him giving you permission without actually seeing it is not something I'm comfortable with.
And the district court advice rights does not count.
It does not. There are different forms, I believe. So, Mr. Gray, your next date will be August 6th at 8:15 a.m. If you have not signed the documents that you need to sign before that date, then I would recommend you come here in person. Otherwise, we're not going to be able to proceed. If you have signed everything that you need to sign, then you can attend by Zoom.
Okay.
Okay, so you are all set for today then.
Thank you, Your Honor.
Okay, Ms. White, are you ready to proceed with Mr. Cooper?
Yes, Your Honor.
Okay, I think we've got everyone here that we need now for that. So, Mr. Fry, you represent on one case, and we wanted to call this one together with the Megan Cooper case, and we have Ms. Hanson Grimes here on that.
Yes, sir. And my client is the court.
Okay. So, yeah, you can all come forward. And Mr. Cooper is on Zoom. There he is. Okay, so this is file 24-22084-FH. 25-22161-FH. People versus Eric Lee Cooper. We are here today for pretrial conferences in both of those cases. First, let me have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
And Ms. White, you want to place your appearance on the record in the 22084 case?
Yes, good morning, Your Honor. May it please the town court. Cena Colbert 152-354, appearing on behalf of Mr. Cooper, who appears via Zoom.
All right, and Mr. Fry in the 22161 case.
Brian Fry, appearing for Eric Cooper.
All right, and then you're also on the record in file 25-22162-FH, People versus Megan Marie Cooper. And let me ask the attorneys place their appearances on the record in that case, beginning again with Ms. Arnold.
Allison Arnold for the people.
Attorney Ashley Hanson Grimes on behalf of Megan Cooper, who is in the courtroom to my right.
Okay. All right, so let me start, I suppose, with Ms. White in the 22084 case. Where do we stand with that today?
Your Honor, I received an email from the prosecution as well as an amended information. And I believe the people can put that information on the record. We are respectfully requesting, with no objection from any of the parties, a remand back to the district court so that we can litigate that particular issue.
That's correct, Your Honor. I wasn't sure procedurally how the most efficient way to handle this is because we did add a count of delivery of controlled substance causing death, which is count number 15 in an amended information. Mr. Cooper would definitely be entitled to a preliminary exam on that added count. So Ms. White and I thought the most expeditious way to handle that would be through a stipulation and order or a court order to remand for exam on that count. I do have a date from Judge Shadler's office for that new preliminary exam on count 15.
Okay, and just so we're clear, I have in the file an amended information and then a second amended information.
Yeah, I can't, I was trying
to.
Right, I think the second information is the correct one. I must have changed like one word. I think it was maybe heroin to fentanyl or something based on a lab test. But in any event, the second information would be the correct information that we want to proceed on. But of course, that would be after remand on count 15 and assuming he's bound over on that count.
All right, so Mr. Cooper is entitled to a preliminary examination on the new charge, so the court will order that the case be remanded for a preliminary examination.
Judge, the date. I do have the date for that. It's November 10th at 1 o'clock because of the length of the exam that we're going to need. That's the earliest Judge Shadler's court could give us.
Okay. Anything else to address with that case then?
No, Your Honor, just if the court's going to do an order, that's great. If not, I can do a stip and order, whatever the court prefers.
If you would do a stip and order, I would appreciate that.
Okay, that makes sense because I'll put the new date in that also then.
Yeah, that would be helpful.
Thank you, Your Honor. And I am not in possession of the second amended information. If the people would just forward that to my email, I would appreciate it.
I can do that right now. Technology.
And there's one other matter, Your Honor. There are several motions that we've prepared on behalf of Mr. Cooper's behalf. However, in the process of preparing those motions, I received the amended information. So I'm assuming for the court procedurally, it would be better to wait to file those motions after the November 10th date, if that would work for the court, considering that I'm assuming the district court would have jurisdiction over this case after this honorable court enters the order.
Judge, I guess I'm not sure because we're only remanding on count 15, but it might make sense to wait on the motions.
I would agree with that. I just would want to just place on the record that motions have been prepared. However, I will amend the date on those motions after the November 10th date.
Okay, I agree. It probably makes more sense to hold off on those motions until we know what the result of the remand is going to be.
Thank you, Your Honor.
All right, and then Mr. Fry, what about the 22161 case?
Yes, Your Honor. In that case, there was also an amended information with an added count. My client has a right in that case as well for a remand for a preliminary examination. At least for right now, my understanding is that is what we would want to do, is have that remanded for an examination. We do not have a date yet. We're gonna have to get one.
All right, Ms. Arnold, anything on the 22161 case from the people?
No, thank you, Your Honor.
Okay. Again, Mr. Cooper has right to a preliminary examination on the new charge, and so the court will order that the case be remanded for a preliminary examination on that new charge.
Thank you, Your Honor. Mr. Cooper, please contact my office.
All right, anything else, Mr. Fry, on that case?
No, Your Honor.
Okay, so that brings us to the People versus Megan Cooper. Ms. Hanson Grimes, where do we stand with that case? I see another amended information. I think I know what's coming.
Yes, Your Honor. I have worked out with Ms. Arnold that the matter will be remanded back to the district court on the amended information. We also are including count 1 on that as they deal with similar issues as to the issue of fentanyl. So those 2 counts would be addressed down at district court on November 12th. We do have a date to that.
We don't have an agreement on that. Those are they're different dates. Count 3 is just the delivery that happened in January of 2025. So I thought we were just remanding on the added count, which would be what Ms. Cooper would be entitled to.
I certainly disagree with the fact that I thought that we had an agreement due to the fact that I did not have any lab reports from that date and time. And I still don't have any lab reports from that specific instance. That was the basis of our conversation regarding that count 1. Because what you sent is for count 3.
Well, you only requested count 3. We do have the lab report for count 1, and I can resend that, I believe. The only thing is the data I got from the court was presuming just a remand on count 3, given the time I requested. And I think I don't think Ms. Cooper's entitled to remand on count 1 since she already waived exam on that. We can make sure you get the lab reports, but procedurally, I only asked for enough time to do count 3.
There clearly was a misunderstanding between myself and the prosecutor. We will be remanding, and I will be, I guess, formally, before this court, requesting a remand. And if that has to be held on a different date and time, then so be it. We are currently set for what I was presuming to be both 1 and 3 based on the conversation that I had yesterday with the prosecutor. If that is only as it relates to count 3, I will, if the court wishes, I will file a formal motion to request that count 1 due to information that came after my client waived with her previous counsel that came before me. I would request that it does go down, and if that's heard on a different date and time, that would be, I guess that's just the way it is. But Your Honor, if the court wishes for me to file a motion to that effect and brief that motion, I'm happy to do that.
I would defer to whatever you want to do. You're obviously allowed to make an oral motion during a hearing. If you want to do that, you can. If you would prefer to file a written motion to brief the issue, you're welcome to do that.
I guess from a procedural aspect, if we are taking the amended information, we're taking the case back downstairs for you and our court dates before you going forward, we would be at a standstill pending what happens on that amended information and that remand. Is that correct?
So once I remand the case to district court, I lose jurisdiction over it. So I wouldn't be conducting any further proceedings until it was sent back up.
So even if it's just one part of the amended information, the whole case goes back down.
That is my
understanding as well. And so at this point in time, it would be up to me and Ms. Arnold if we are going to if we were going to have separate, I guess, separate prelims on separate things if we need that. It was a miscommunication on behalf of both of our offices. However, my stance is that count 1 also needs to be reviewed, as there's evidence that came in after her waiver that I do believe affects her waiver.
Okay, so do you want time to file a written motion to brief that, or?
I can do that, but Your Honor, if you're sending us back down to be heard in November,
So
like, it doesn't go before you, or
I'm
doesn't go down.
not gonna make a decision. I haven't remanded anything
Okay.
yet, and I'm not gonna make a decision. I'm not gonna order a remand until we resolve this issue.
Okay.
Because
I think
I'm
that
not-
makes
don't-
sense.
don't
I
wanna-
can speak with Ms. Grimes. It could be too that because there were multiple search warrants at the Cooper's residences where, you know, a lot of drugs were found and we have multiple things occurring on different dates, it might be that as to count 1, there are not actually lab reports, because we don't always send things to the MSP lab before a trial's set if we have a true narc result. So it could be that on that count, there's only a true narc result at this point. We did have a misunderstanding yesterday, and I can speak with Ms. Grimes about that. And then I would just ask the court if we can agree to a remand, if we can just submit a stip in order in the meantime before a motion's filed.
That would be fine. If you talk about it and reach a resolution, I'm willing to do that. What I will say with respect to count 1 is that I don't believe I can remand simply because you have stipulated to a remand. The court has to make findings since there was a waiver. So if the agreement if the agreement includes count 1, I think a motion has to be filed either way with respect to count 1.
Okay.
Okay.
All right, so I can set this for August 6th at 8:15 if you think that's a sufficient amount of time to do what needs to be done.
That should be fine, Judge.
Can you repeat yourself, Your Honor? I'm sorry.
I can set it for August 6th at 8:15 if that gives you enough time.
All right.
I'm happy to meet with Ms. Grimes today or tomorrow or Friday to go over what the lab results are. It might be better if she comes in person so we can sit down and look at it together, if that works.
And I'm happy to do that. And if we need to secure a date after that, I can do so. Your Honor, if this does need to be heard, I would ask that if we could please go into September. Due to scheduling conflicts on my behalf for the month of August.
And do September 3rd.
Okay, that's fine.
Wait, hang on 1 second. We're going to September 3rd. Let me see if that. Yes, that's fine. September 3rd at 8:15.
Correct.
And do you want us to do the stip in order on that one?
Yes, I would appreciate that.
Okay.
All right, anything else we need to address with that case?
No, thank you. Judge, because Eric Cooper, we're only remanding the 24 case. Do we need to set a new pretrial in Mr. Fry's case? Or are we just going to wait till the other
Mr.
case?
Fry had asked for a remand on his amended information as well.
Oh, okay. I'm sorry. I forgot I amended that one. All right, sounds good. We'll amend those. We'll do those all for that date.
Thank you so much. I'm so glad that you brought that up, Madam Prosecutor. Judge, if I might, or regarding Mr. Cooper, may I, Judge? I know the case has been called and we moved to another case. However, I am for the first time in receipt of the second amended felony information. The prosecutor emailed that to me just now. Judge, may I place one other issue on the record?
Go ahead.
Thank you. As I review the felony information, it is 4 pages, Judge, and it does consist of 15 counts as well as a habitual offender notice. Judge, when I have reviewed the discovery and now that I look at the second amended information, I too would like to file a motion regarding remand, Judge. I believe that in all fundamental fairness, Mr. Cooper would be entitled to a remand on all 15 counts. And here's why. Because when I look at the amended information regarding the delivery causing death, all 15 counts are intertwined. One is as a result of the other. So perhaps the counsel prior to myself may not have waived the preliminary exam on the other 14 counts had count 15 been a part of the initial complaint, Judge. They are all based upon one another. The count 15 delivery of a controlled substance causing death would be a result of the other counts, Judge. So in fundamental fairness, he would be entitled, with the court's permission, of course, to remand on all 15 counts.
Judge, I think
I'm sorry, go ahead, Ms. Arnold.
Sorry, I think I was trying to make this more efficient, and all I've done is make it less efficient. I think what I will do is nolly the added counts, charge them in separate files, and then I'll do a motion to consolidate in circuit court later if we deem that appropriate. So I think I'll do that to avoid the confusion, because it's too onerous, I think, to do it this way. So I'm going to file a nolly today on the added counts as to Mr. Cooper and Ms. Cooper, and we can just set new pretrial dates. And then if new files end up coming up, we can look at consolidation or whether one trial is appropriate or not.
And Judge, I would just like to place on the record that that is not only unfair. So what that does is that prevents Mr. Cooper from remand on the other 14 counts. So it sounds to me like the prosecutor agrees that based on the way the case is charged, that he would be entitled to remand as she has charged the case. So in order to avoid and allow Mr. Cooper remand on the other 14 counts, she would simply dismiss this information and refile with a different case number. And in that case, Judge, I was not counsel of record. I will still ask this honorable court to allow me to file a motion to remand this particular case that will have 14 counts after she dismisses this particular file.
Yeah, I think.
Okay. We are going beyond what I have time for with this case today. So you don't need my permission, Ms. White, to file a motion based on something that the prosecutor does. I don't understand myself to have any authority to tell the prosecutor that she can't file a nollie with respect to a certain count. I think that falls within prosecutorial discretion. And so if she doesn't want to charge something or wants to dismiss a charge, that is within her right. And what happens after that is something that we can address through motion practice if necessary.
Thank you, Your Honor. I appreciate the court just simply being respectful to the court. But if she does, in fact, dismiss.
Okay, Ms. White, I don't want to have an extended discussion about if this, then that. I just don't simply have time to continue with this today.
Yes, Your Honor, I understand.
We are talking about something that the prosecutor has stated an intention to do. If she does that, you can file an appropriate motion and I will deal with it when it is appropriately before the court.
Thank you, Your Honor. I appreciate the court.
Ms. Hanson-Grimes.
On September 3rd, may I have a time that is at the end of your docket call, just in case I do intend to file a motion, Your Honor? As you had instructed previously, I feel like that would give you.
I'll ask you to contact Francis and arrange that. I don't have that information to do that. I don't know what's coming after my docket call on.
And Judge,
And that's only if it's necessary. I just know, like to hear these matters on Wednesdays.
and I'm going to nollie the added count in that file also. And then we can fight about whether everyone's entitled to an exam on counts they've already waived on or not.
So assuming, Judge, that the prosecutor is going to do that, we will no longer appear on November the 10th at 1 p.m.
I would assume that to be correct. That was the date you had worked out with district court, and it doesn't sound like these cases at the moment are going back to district court. They may in the future, depending on what happens, but that's not happening now. So we do need new pretrial dates in all three cases. Then we had one for Ms. Cooper's case on the 3rd. Why don't I set the other two for September 3rd also?
Judge, I apologize. I've got a jury trial on a capital case that begins on the 3rd. Is the court available the week of the 8th?
So that'd be September 10th. Yeah, so I'm actually not here that day, so we can't do it on the 8th. I could do it on the 27th, August 27th or September 17th.
I'm sorry, I didn't hear the September date, Judge.
September 17th.
Will that be via Zoom or in person, Your Honor?
That would be Zoom.
Okay, September 17th via Zoom.
Correct. And so Ms. Hanson-Grimes, you were on the 3rd. You want to remain on the 3rd or be moved to the 17th with Mr. Cooper's cases?
We'll stay on the 3rd, Your Honor.
Okay. All right, so Ms. Cooper's case will be September 3rd at 8:15. Mr. Cooper's case will be September 17th at 8:15. Anything else with any of these cases that we need to address today?
No, I apologize for that.
One last question, Judge. Would the court prefer that I reach out to the court for a motion hearing date in the interest of time?
I would say if you're going to file a motion, we can probably just hear it on the Wednesday, September 17th date.
Thank you. I appreciate the court. Thank you.
Okay. Thank you then. I think we're all set.
Okay, thank you, Your Honor.
Thank you.
Okay, Mr. Noe, are you ready to proceed with Mr. Maples?
Maples, yes, Your Honor.
This is file 23-21397-FC People versus Stephen. I'm sorry, we're having an issue with our recording system. We'll continue as soon as that is resolved. Okay, so file 23-21397-FC People versus Stephen Maples. We are here today for a pretrial conference and proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Good morning, Your Honor. Charles Noe on behalf of Mr. Maples.
Okay, I think we adjourned this last time because we were waiting on the report of an expert. Where do we stand with that?
Judge, I discussed this matter with Ms. Arnold. My expert has checked in with me, going to be meeting with Mr. Maples in the next couple of weeks. It should have a report for us, hopefully a couple weeks after that. So we're hoping to get one more pretrial. I looked at the calendar, either August 6th or 13th. Update the court further, and hopefully we have that done. And then obviously Miss Arnold, if she needed time with that, in terms of her forensic evaluation, look at that. Obviously that would be fine as well. But we're looking at possibly August 6th or 13th as a pretrial date.
Okay, Ms. Arnold, anything from the people side?
Nope, that's all agreeable with us, Judge.
Right. So let's set it then for August 6th at 8:15. Mr. Noe, would you do that stipulation in order for the adjournment?
It'd be my pleasure. Miss Arnold, may I sign that with your permission, please?
Yes, you may.
Very well. Nothing further.
Okay, thank you. Mr. Maples, you can let the officer with you know that you're done with court for today.
As you wish, Your Honor.
Okay, Mr. Dagger-Margosian, are you ready with Mr. Miller? Yes. Mr. Miller, if you want to come forward. This is file 25-22221-FH People versus Sean Kenneth Miller. We are here today for a pretrial conference, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Your Honor, Michael Dagger-Margosian for Mr. Miller.
And Mr. Dagger-Margosian, where do we stand with Mr. Miller's case?
Your Honor, Mr. Miller will be entering the plea today.
Okay, do you want to state your understanding of the plea agreement, and I will ask the prosecutor to confirm.
Your Honor, Mr. Miller will be pleading guilty to the amended information count 1, as well as count 6. The remainder of the information be dismissed. There is a sentencing agreement based on the anticipated sentencing guidelines. There is a sentencing agreement that Mr. Miller would be sentenced to 4 years on the minimum, 4 years MDOC on the minimum.
Mr. Bayonetto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor. I forwarded a plea agreement to Mr. Dagger-Margosian this morning. He obviously has not had the ability to sign that being in court, but that does cover everything that he did place on the record the only additional item that is covered in Section 9 of the plea agreement. The defendant will have to register under the Michigan Sex Offender Registration Act pursuant to this plea. But everything else is factually accurate, and Mr. Dagger-Margosian indicated he would send that signed plea agreement into the court when he gets back to the office later.
If one of you would like to forward that to me, I can print it and you can sign it now if you prefer.
I can send it to you right now, Judge.
Okay, so bailiff's handing you a copy of the plea agreement and the advice of rights form. Okay, so I have the signed advice of rights and plea agreement form. Mr. Miller, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
You are Sean Kenneth Miller?
Yeah.
Mr. Miller, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one, accosting children for immoral purposes?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $4,000 fine?
Yes.
Is it also your intention to plead guilty today to count 6, aggravated child sexually abusive activity?
Yes.
Do you understand maximum possible penalty for that offense is up to 25 years in prison and or a $125,000 fine?
Yeah.
Are you satisfied with Mr. Dagger-Margosian and the advice that he has given?
I am.
Either the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Van Edo?
That's correct, Your Honor.
Mr. Dagger Margosi?
Correct, Your Honor.
Is that also your understanding, Mr. Miller?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present to your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Miller, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
I understand.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
I understand.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand, Mr. Miller, that by entering into this plea, you will be required to register under the Michigan Sex Offender Registration Act?
I do.
Do you have any questions about any of the rights that I've described to you?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about February 2nd, 2025 through February 6th, 2025, you did commit the offense of accosting children for immoral purposes?
Guilty.
How do you plead to the charge that on or about February 2nd, 2025 through February 6th, 2025 in the city of Tecumseh, County of Lenawee, State of Michigan, that you did commit the offense of aggravated child sexually abusive activity?
I did go there. Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that by pleading guilty, you're giving up your right, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record here today, or that it was not your own choice to enter the pleas?
Sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Miller to plead guilty today?
No, Your Honor.
No, Your Honor. Mr. Miller, is it your own choice to plead guilty?
It is.
Has your attorney promised you any particular sentence or estimated what your sentence would be, other than as we've talked about it on the record here today?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
I understand.
Mr. Dagger Margosi, do you want to cover the factual basis?
I can, Your Honor. Mr. Miller, between the dates of February 2nd and February 6th of this year, were you in the city of Tecumseh, County of Lenawee, State of Michigan?
I was.
All right, and between those dates, did you attempt to solicit an individual who you believed to be under the age of 16?
I did.
Okay, and that was with the intent to commit a sexual act? Yes. Okay, and in actuality, it was, there wasn't that person under the age of 16, but you thought that there was.
Yes.
Okay. Your Honor, I think I'm satisfied with count one.
Mr. Bayonet, are the people satisfied with the factual basis for count one?
Yes, Your Honor.
All right, and moving to the other count, Mr. Miller, on those, during that same time range, did you, on your phone, did you possess pornography that depicted bestiality?
I did.
All right, and did you either make or copy or reproduce those images by sending it to another individual, whether a group chat or a friend of yours?
I did through group chat.
Through group chat, okay. I think I'm satisfied with that.
Mr. Bayonet?
Your Honor, the only thing I would ask is that the defense stipulate that video did depict child sexually abusive material. But other than that, I'm satisfied.
We'll stick with that, Jeff.
All right, Mr. Miller, the video that you're talking about involved children, is that correct?
Yes.
Has the court complied with MCR 6.302 B, C, and D, Mr. Bayonet?
It has, Your Honor.
Mr. Dagenberg?
Yes, sir.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Miller has had full knowledge of his rights and he's had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed on the record here today, which I will take under advisement pending preparation of pre-sentence investigation report. I will refer this matter to the probation office for a pre-sentence investigation. You will set sentencing for August 28th at 8:15 a.m.
Is it August 28th?
Correct. Mr. Miller, someone from the probation office will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background. So Ms. Walsh, he is here in the courtroom. Should he just stop over at the probation department and pick up his packet?
Yes, please.
So Mr. Miller, he'll just step across the hall to the probation department. They'll have a packet of information to give you. Okay. All right, so you're all set for today.
Thank you, Your Honor.
Okay, Mr. Murphy, do you need to speak to Mr. Let's see, Mr. Spike?
If I could briefly, Your Honor, please.
Okay, Mr. Spike, If you will step out to the hallway, there's an iPad out there, and I can put you in a breakout session with Mr. Murphy. I'm going to send you a request to unmute. And if you give me just a moment, I will set up that breakout session. Mr. Spike, then you can go forward to the podium. Is file 25-22288-FH, People versus Benjamin Paul Spike. We are here today for a pretrial conference, and we're proceeding today by partially by Zoom and partially in person. First, can I ask the attorneys to place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy, appearing on behalf of Mr. Spike.
And you are Paul Brian Spike. Sorry? You are Paul Brian Spike? Benjamin Paul Spike. I'm sorry. Getting the wrong thing.
Benjamin Paul Spike.
Thank you. Mr. Murphy, where do we stand with Mr. Spike's case today?
Your Honor, there was a offer relayed by the prosecution. I got that yesterday, the day before. I spoke with my client yesterday about it. We've scheduled an appointment for him to come into my office next Thursday at 2 p.m. to discuss things more. So if we could just adjourn this out for another pretrial, just whatever fits the court's schedule best. I think that would be the best step right now. And then at that point, we'll update the court if we're going to set trial or accept an offer.
Okay, Mr. Sneed, anything to address from the people side?
No, thank you.
All right, let's go with August 6th then at 8:15.
You say August 6th at 8:15, Your Honor?
Correct.
Thank you, Your Honor. My office will prepare the stipulation order for that date and time.
Thank you. So we're all set. Mr. Spike, your next date is August 6th at 8:15 a.m. Thank you. Thank you.
Thank you, Mr. Spike. I'll see you next Thursday, okay?
Thank you.
Thank you.
Okay, so Mr. Adams, we're just waiting on Ms. Dumont to get logged in. So she's here. We'll call your case. Okay. Mr. Harris, Ms. Rambert, we're waiting for Mr. Malero. As soon as he gets here, we'll call your cases. And then, sir, what case are you here for?
DRR.
Okay. All right, and that is Mr. Malero's case also, so as soon as Mr. Malero gets here, we'll get to that case. Yes, Mr. Murphy, you need to speak to Mr. Rutledge.
If I could, please, Your Honor. Thank you.
Hello.
Okay, Mr. Rutledge, if you give me a moment, I'm going to put you in a breakout session so you can talk privately to Mr. Murphy.
Okay.
Be in here. Hey, now you're like that.
Okay, Mr. Murphy, Mr. Rutledge had dropped out of the meeting. I don't know if you were able to finish your breakout session with him or not.
Yeah, I was. I'm ready to proceed on the record when he's ready.
I'm here.
Okay, this is file 25-22275-FH, People versus Lucas Allen Rutledge. We are here today for a pretrial conference and proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Matthew Murphy, appearing on behalf of Mr. Rutledge.
Okay, Mr. Murphy, where do we stand with Mr. Rutledge's case today?
Your Honor, I do apologize to the court and to Mr. Sneed. Mr. Rutledge was trying to get a hold of me for a couple of weeks now. I was out on vacation. We're trying to get an appointment scheduled for him to come into the office and view the video footage, the evidence that we have. I did have him scheduled to come in now next Thursday at 3 o'clock. So if the court would be okay to adjourn this for one more pretrial, that's what I'm asking for. I don't want to set trial yet. I want to have Mr. Rutledge view those videos and then talk about it at length, the people's offer at length. So if Mr. Steve wouldn't have an objection, that's what we're asking for at this time.
I have no objection. I believe this is the first pretrial, Judge.
Okay, let's go with August 13th at 8:15.
Yes, Your Honor. My office do a stipulation order for that date and time, August 13th at 8:15.
Okay, so Mr. Rutledge, your next date is August 13th at 8:15 a.m. You can log in using all the same Zoom information that you used today.
Okay. Thank you.
Okay, so you're all set.
Thank you, Mr. Rutledge. Give my office a call if you can't make it next Thursday, okay?
All right. Yep.
Thank you.
Thanks.
Okay, and Mr. Murphy, did you have anyone else today?
I don't think so. I was just trying to check my defender data and it's freaking out on me, but I don't think I have anything left. So I was going to go ahead and log off now if that's okay with Your Honor.
Okay, thank you. Have a nice day.
Thanks, you too, everybody.
Good morning, Ms. Demont. Mr. Adams is here in the courtroom. Do you need to speak to him? I'm sorry, I was not able to hear what you said.
No, Your Honor. Let me switch my Wi-Fi.
Okay, it sounds better now. So, Mr. Adams, you can come forward, please, if you want.
Your Honor, no, I don't need to speak with him. We're here to just set a jury trial date.
Okay. This is file 25-22140-FH, People of the State of Michigan versus Richard Joseph Adams. We are here today for a pretrial conference, and we are proceeding today partially in person, partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed. You said something, Mr. Sneed?
Isaac Sneed for the people. Sorry.
Katerina Dumont for Mr. Adams.
And sir, you are Richard Joseph Adams.
Yes, sir.
Okay. Ms. Dumont, where do we stand with Mr. Adams' case today?
Your Honor, after the last court date we had, I did speak with the prosecutor with regards to a possible resolution that I gave that resolution to Mr. Adams. At this time, he does not wish to take that, and so we would like to just set for a final pretrial date and a jury trial, please.
Okay, and how much time do you think you will need for a trial?
2 days, Judge.
All right, Ms. Clark, could you find us a 2-day jury trial date, please?
Yes, Thursday, September 25th at 9 and Friday, September 26th at 9.
That's good for the people. Thank you.
Your Honor, this is actually my case. I apologize. I was stuck over in Judge Anzalone's court. I am actually going to be out September 26th.
We have October 9th at 9 and October 10th at 9 back up to a jury trial.
Yeah.
I won't be back in the state until October 8th, I believe. Could we go after that?
October 28th at 9 and
Yeah. That's a good
I'm
one.
sorry, Ms. Clark, I accidentally muted your device.
oh, okay, thanks. October 20 October 28th at 9 and October 29th at 10:30 backed up to a civil jury trial.
That works for me.
That works for me as well. Thank you.
Okay, so let's do a final pretrial on October 22nd at 8:15. Court will issue a scheduling order. Is there anything else we need to address today?
Not from the people, Your Honor.
Your Honor, I do believe that the prosecution has indicated to me they would be filing a motion to join trials for co-defendants. I guess I was just wondering the status of that.
That is correct, Your Honor. I think the co-defendant is not up for another week or two, but I will be asking to have the cases joined. But I will make sure that's done well in advance of any potential trial date.
Thank you.
All right, we still have an outstanding order for fingerprints for Mr. Adams. So I'm going to have the bailiff hand Mr. Adams another copy of that. Mr. Adams, you need to.
I've had that done in Monroe County in April, end of April, beginning of May. A young lady did it in Monroe County.
For this case or for a case?
Yes, sir. It's the only case I got. They sent it to me and I took care of it April, beginning of May. Young lady did it in Monroe County.
Where did you go in Monroe County?
I went to the big state post. I'd have to look on my phone out in the car to tell you the address. It's a big state post on in Monroe.
The state police post?
Yes, sir. I went there into April, probably 10 days after I received my thing on my email. I went. Yep, same paper like this.
All right, we'll check into that.
So do I wait or do I go get this? What do I do?
Don't do anything with that now. We will check into that and see if we can track that down.
Okay, thank you.
So you're all set.
All right, thank you. Thank you, ma'am.
Thank you.
Thank you.
Okay, Mr. Molero, we have Mr. Harris here in person. Do you need to speak to him?
Yeah, if I could, Judge, I guess.
All right, Mr. Harris, if you'll step outside to the iPad, I will set you up with a breakout session with Mr. Molero. Okay, and Mr. Harris, you'll need to unmute that device also. Okay.
Thank you, Judge. Thank you.
Oh, yes, please. Thank you.
So it's Kelly and Judge first. Could we have Michael Dunn and Dustin Gerhardt in rooms with the judge, please? Michael Dunn and for Old Saver, Michael Dunn. Yep, and Dustin Gerhardt. Okay. Thank you. Bye.
Okay, Mr. Harris, you can come forward to the podium. Is file 25-22314-FH People versus Dewan Harris. We are here today for a pretrial conference in this case, and we are proceeding to, I'm sorry, we're here for an arraignment in this case, and we're proceeding today partially in person, partially by Zoom. We're just going to have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Dewan Harris.
And sir, you are Dewan Pfeiffer Harris?
Yes, sir.
Mr. Malero, does Mr. Harris wish to have the information read?
Your Honor, at this time, we'd waive reading of the information, waive any defects as the time and place of service. Mr. Harris would plead not guilty to counts 1, 2, 3, and 4, as well as the habitual offender fourth notice. We further acknowledge receipt of the witness list. Ask the court to set a pretrial. Judge, we would ask that the pretrial be set out past 45 days. The basis for that request is that at the time of this exam, this was done by an exam. Probably gonna have to order the transcript anyways, but the police filed new charges against Mr. Harris, and that's just scheduled for a probable cause tomorrow. while that works its way through district court.
Okay. Court will enter a not guilty plea and set a pretrial for August 27th at 8:15 a.m. Is there
Thank you,
anything
Jake.
anything else that we need to address today?
No, thank you.
Not at this time, Judge. Thank you.
All right, Mr. Harris, your next date is August 27th at 8:15. You can attend that in person like you did today, or you can attend by Zoom if you prefer to do that. Baler has our Zoom information. So you're all set for today.
All right, thank you. Have a good one.
Thank you.
Hey, Dwan, my name is Darren. I'm with Pretrial Services. I'm going to meet you out in the hallway there for a second.
So he's the one, he's monitoring your bond conditions, so we just need to speak to you. Okay. Okay, and then Mr. Malero, do you need to speak to Mr. Gerhardt?
I don't think so, Judge.
This is file 25-22268-FH, People versus Dustin Austin Gerhardt. We are here today for a pretrial conference. There are also pending contempt of court for violating bond conditions and failing to appear. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Dustin Gerhardt.
And sir, you are Dustin Austin Gerhardt?
Yes, Your Honor.
All right. Mr. Malero, where do we stand with Mr. Gerhardt's case?
Your Honor, I'm going to ask to adjourn the case and the contempt out perhaps 3-4 weeks. And then I'd like to address the issue of bond.
Okay, we can set it for August 6th at 8:15. And what is it that you would like to say about bond?
So, Judge, I don't know if the court recalls, but we were here, I think it was a week ago. Mr. Gerhardt had missed his arraignment, but upon me talking to him, he came to the court in the morning, came back in the afternoon. The court expressed concern over Mr. Gerhardt's testing positive and missed drug screens. I have since spoken to Mr. Gerhardt. He has now been in custody at least a week, so I believe he would be clean, or should test clean. He has a family to take care of, and he is an integral part of that family dynamic and providing support so they do not lose their housing. Mr. Gerhardt's well aware of the court's concern about him maintaining himself so that he is safe due to the consumption of illegal substances that have been alleged. He assures me, and he has assured the court, that he can remain clean, and I think with drug testing, the court can assure itself of that. Clearly, the court has no problem in putting Mr. Gerhardt in jail. Mr. Gerhardt knows that. I would argue to the court that that is sufficient incentive for Mr. Gerhardt to remain clean, and if he doesn't, the court can then put him back in jail until the matter is resolved. I would ask the court to consider releasing him on a PR bond on the matters with the appropriate drug testing, so he can show this court he can remain clean. I believe that would also, him being clean, help him maintain a more rational approach to resolution of this matter, and would help us reach resolution in perhaps in a sooner venue than a later venue. So that would be the basis of my request, Your Honor.
Mr. Sneed, do the people have any position on requests related to the bond?
Your Honor, we have no position on his continued incarceration. I would apprise the court. I do see a note back from May 28th that there was a bond of $25,000 cash or surety that may have been on the failure to appear warrant. But I just want to advise the court of that if that somehow would weigh into his bond or bond amount for today's purposes. Thank you.
Judge, back on June 26th, he did turn himself in on the warrant. When asked, he stated that he would be positive for meth. Back in May, we had 3 positive meth screens. You did want him to be evaluated by CMH. They did evaluate him. He was approved to go to Hope House. But Mr. Garrett told the evaluator that if he was going to get out of jail today, he didn't want to go to treatment. But if he's going to remain in jail, he would go to treatment.
And Judge, I would only add that Mr. Gerhardt's failure to appear, I believe, was a miscommunication on my part with him. He did have a pending misdemeanor matter in district court for which he has always appeared. And I think between that case, this case, and him and I talking, there was a misunderstanding. So I believe the failure to appear is not, should not be detrimental to any consideration for him being released and or of a bond.
Well, my concern here is with the drug use, and if I don't know if he has good cause for not appearing or not. We can have a hearing if you want to have a hearing on that, but what I'm primarily concerned with is the drug use. We had positive tests on May 19 and May 28, and we had Mr. Gerhardt indicating when he turned himself in that he would also be positive. So he's in active use right now, and one short period of being clean because of incarceration, I don't think satisfies me that there's likely to be continued compliance going forward simply on the basis of a PR bond. We tried that. It didn't work. I have evidence about what Mr. Gerhardt has done well on PR bond. And it's also concerning that he's only interested in rehabilitation if it's a way to get out of jail, and that he doesn't want to do it if he can get out of jail otherwise. So I think under the circumstances that the bond is appropriately set, and I'm going to deny the request to modify bond.
Thank you, Your Honor.
Mr. Gerhardt, you can let the officer with you know that you're done with court for today.
Yes, Your
Honor. Mr. Malero, do you need to speak to Mr. Dunn?
I do.
And Coller. This is file 23-21350-FH and 24-21823-FH. People versus Brian Cody Coller. We are here today for an arraignment on alleged probation violation, and we're proceeding today by video conference. Courtroom is also open to the public. The record should reflect this matter was set for hearing at 8:15 a.m. this morning. It is now 10:37. Mr. Coller is not present in the courtroom, nor is he logged into the Zoom session. He has not been at any point this morning. I am going to issue a bench warrant for his arrest for the failure to appear in each file, and I'll set bond on the bench warrant in each file in the amount of $15,000 cash or surety. Is file 24-21852-FH, People of the State of Michigan versus Tanya Nash. We are here today for an arraignment on a alleged probation violation. We are proceeding today by video conference, and the courtroom is open to the public. The record should reflect that this case was set for hearing at 8:15 a.m. It is now 10:38 a.m. Ms. Nash has not appeared either by logging into the Zoom conference or by being present here in the courtroom. I am going to issue a bench warrant for her arrest and set bond on that bench warrant in the amount of $15,000 cash or surety. Okay, Ms. Underwood, I think those are the
Thank you, Your Honor.
other ones I had for you, so I think we're all set.
Yep. Thank you.
Thank you. is file 25-22315-FH People versus Michael Deshane Dunn. We are here today for an arraignment in this file, and we are proceeding today by video conference. First, I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Michael Dunn.
And does Mr. Dunn wish to have the information read?
Your Honor, at this time, we would waive the reading of information. There has been a plea offer, and I apologize for not having this all buttoned down before the arraignment, but it kind of was short notice. Mr. Dunn's going to plead guilty to an amended count 2, possession of a controlled substance, a 4-year felony, that the people would have no objection with him entering recovery court program, and upon successful completion, there will be a dismissal of the charges. I'm sorry, did someone say something?
Nope.
Oh, okay. And pursuant to paragraph 4, count 1 and habitual offender would be dismissed. And don't see any amount of restitution. And there is no Cobb's evaluation. That would be the terms of the plea agreement.
Sir Sneed, is that a complete and accurate statement of the plea agreement?
Yeah, it is accurate, Your Honor. And we don't have it amended prepared. I wasn't aware he was accepting the plea agreement until this morning.
All right, are you able to prepare one now?
Yes, we will.
And Your Honor, just for clarification, I believe his bond permits him to be released to rehab, but there's some confusion on our end about that. I just wanted to make sure that that's the case in this case.
Well, judges, we have Michael Dunn in our holding. Would you be able to take him and advise of rights for him to sign to the judge? He's in a Zoom room 4. For Judge Olsen. He's taking the plea and you need the advice of rights form signed. Thank you. Bye.
It does appear his bond was modified in district court to allow him to be released to an inpatient treatment facility.
Great. Thank you, Judge.
All right, so as soon as I get that amended information from Mr. Sneed, we will continue. In the meantime, Mr. Malero, do you need to speak to Ms. Rambert?
Yeah, I probably should talk to her too.
Okay, Ms. Rambert, if you'll step into the hallway, I will put you in a breakout session, Mr. Malero. going to ask you to unmute as well. Okay, Ms. Rambert, you can come forward to podium, please. This is file 25-22264-FH, People versus Layla Precious Rambert. We are here today for a pretrial conference in this case, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Layla Rambert.
Mr. Malero, where do we stand with Ms. Rambert's case today?
Judge, I'm going to ask to adjourn the matter. Ms. Rambert and she just brought something to my attention. I need to review. And if so, it may be determinative of what happens with this case.
All right, Mr. Sneed, is there anything we need to address from the people's side?
No, I have no objection to that request.
I just would ask Mr. Sneed if he could verify the date of offense on this matter. I think that would be helpful.
I'll have to review the file and get back with you, Sam.
Yeah. I wasn't expecting you to do it right now, but if you could verify that, I'd appreciate it. That would probably decide what happens.
All right, we'll go with August 13th at 8:15. Mr. Malero, would you do that statement work?
I will, Judge, since you're so nice to let me adjourn it.
Okay, so Ms. Rambert, your next date is August 13th at 8:15 a.m. You can attend in person like you did today, or if you prefer Zoom, you can do it by video conference. Okay, I have that amended information now for Mr. Dunn. So Mr. Dunn, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir, Your Honor.
And you are Michael Deshane Dunn?
Yes, sir, Your Honor.
Mr. Dunn, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, possession of a controlled substance of less cocaine, heroin, or another narcotic of less than 25 grams?
Yes, sir, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine?
Yes, sir, Your Honor.
Are you satisfied with Mr. Malero and the advice he's given?
Yes, sir, Your Honor. Did a very good job.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it here today. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Malero?
That's correct, Judge.
Is that also your understanding, Mr. Dunn?
Yes, sir, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Dunn, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir, Your Honor, I understand.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir, Your Honor.
Do you understand that you're giving them up?
Yes, sir.
How do you wish to plead to the charge that on or about May 23rd, 2025, in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of possession of cocaine, heroin, or another narcotic of less than 25 grams?
Guilty, Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, sir, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Dunn to plead guilty?
No, Your Honor.
No, Judge.
Mr. Dunn, has your attorney promised you any particular sentence or estimated what it would be other than as it's been discussed on the record today?
No, sir, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes, it is.
Did someone at the jail bring you a copy of an advice of rights form?
Yes, I received a copy and signed it, Your Honor.
Okay. Mr. Malera, would you like to establish the factual basis?
Yes, Judge, if you give me a moment. Mr. Dunn, is it true that on or about May 23rd of 2025 in the city of Adrian, Lenawee County, state of Michigan, you were in possession of a controlled substance that could include cocaine or some other controlled substance?
Yes, sir, Your Honor.
I am not a judge, so, but thank you for the.
My bad, my bad.
And you knew that this was contrary to Michigan law,
Yes, I did.
and you did not have any valid reason to be in possession, or I should say legal reason to be in possession of such illegal substances?
No, sir.
Is the court and the state satisfied?
I just specify it was methamphetamine. He's pleading to the greater offense to satisfy the lesser charged.
That's fine. You understand it was methamphetamine?
I do.
All right. Now is the state and the court satisfied?
Yes, thank you.
Yes, has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you.
Mr. Malera?
Yes, Judge.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Dunn has had full knowledge of his rights, and he has had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we discussed on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for August 28th at 8:15 a.m. Mr. Dunn, someone from the probation department will be in touch with you to do a pre-sentence investigation. When you do that interview, please be truthful about the offense and about your background.
Yes, sir, Your Honor.
All right. Is there anything else we need to address with this case today, Mr. Malera?
No, Your Honor, I believe the court has satisfied everything.
Mr. Sneed?
No, thank you.
All right, Mr. Dunn, you can let the officer with you know that you're done with the court for today.
Yes, sir.
Thank you, Judge.
Thank you. I think that is everything that we have for this morning.
All right, have a good morning, Judge. Thank you. Thanks, Sam.
Yep, thank you.
DLC is here. We have 11:30.
Oh, okay.
You just got here, so they're on the way up.
Okay.
Yeah, Brian, like crazy.
What?
What's rain?
Yeah, she's had most of it.
I think it's just,
I don't like
I think it's, me, but no, there's couple times.
Francis.
Yes.
Good morning. Am
Good
I
morning.
correct that we had two pleas?
Yeah.
Michael
That's what I
Dunn.
got so far.
Are we not done? No, we're not. Okay. I wondered where he was going. We're not done, are we, Judge?
We are done with the morning docket. Yeah, I have one, a motion hearing, but that doesn't, I don't think you need to be here for that. It's someone that's already been sentenced.
Okay, just double checking. Thank you.
No problem. Okay, we can bring in Mr. Jones. This is file 23-21615-FH and 23-21616-FH, People versus Maurice Leroy Jones. We are here today for a hearing on Mr. Jones' motion to correct an invalid sentence. We are proceeding today in person. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brody?
Jennifer Redmond on behalf of the people. Daniela Cohen on behalf of the State Appellate Defender Office, and Mr. Jones seated to my left.
All right. This is Mr. Jones' motion, so you can proceed with any arguments you have at this point.
Thank you, Your Honor. Would you prefer that I stand at the podium?
Yes, please.
One second. Sorry, I'm having technical delay. This is our motion to correct invalid sentence for Mr. Jones this morning. I won't, go over everything in our motion. I think it's pretty clear, but the basis of our argument, Your Honor, this morning is that Mr. Jones was sentenced before the People versus Hines case came out of the Court of Appeals, which says pretty clearly in an opinion by now Justice Hood that the doubling of the guidelines automatically is no longer allowed, as is what happened in this case. And we think that this holding itself is such that Mr. Jones's Cobb's evaluation, while otherwise accurate, was made under the pretense that it was automatically going to be the case that the guidelines should be doubled. He was therefore then given a maximum cap under this Cobb's evaluation of 25 months, when in reality, his correctly scored guidelines range would have been 10 to 23 months. On the basis of that, we think that Mr. Jones is indeed entitled to resentencing. I'm happy to respond to the arguments in the prosecutor's response. I'm sorry, I would have actually filed a written response, but for some reason our office didn't get their response until I called her around 3 p.m. yesterday. Just to begin, based on the written response. First, as it relates to her argument with regard to the Cobb's plea, she cites People versus Wiley, which unfortunately the citation is not complete there, because what's most important for Mr. Jones's case is that because he, quote, understandingly and voluntarily entered into a plea agreement which is not then finished, but the rest of that quote is to accept that specific sentence. In this case, Mr. Jones was not agreeing to a specific sentence in his Cobb's agreement. He was only agreeing to a cap at 25 months, making the Wiley portion of that incorrect here. All we're saying is that because of Hines, the range should have been different, and he, under Francisco, is entitled to be sentenced under accurate information, which of course was a mistake of law at the time, because we now know under Hines, the range should be 10 to 23 months. Moving forward, in her second argument with regard to Hines, I did let her know this, but we believe that there was a bit of a mistake in the block quote that she cites on page 5, trying to sum up the Hines court in relation to our argument today. That was actually in regard to a completely different issue in Hines. That was with regard to the doubling of the statutory maximum. I concede that Hines is a bit confusing as it's written, but actually where our issue starts is a bit below that block quote. When it says with regard to doubling the guidelines, we now know that is automatically, doing so automatically is not allowed. So I would also just note that she does quote also Myers 2025 case, and I would just like for the record to note that this is a case that our office is working on, and the only reason the Michigan Supreme Court remanded the case to the Court of Appeals is because at the time Hines again had not come out, so we actually asked the Michigan Supreme Court to remand it to the Court of Appeals in light of Hines for supplementary briefing, and that's happening right now. So we don't believe that there's any question as to the Hines holding there. And with that, I will wait to respond to the prosecutor. Thank you.
Thank you. Ms. Wu?
Your Honor. So when I was initially reviewing this motion and weeding through Hines, which I think has some issues in it, unfortunately, that was never appealed to the Michigan Supreme Court. It is obviously a binding decision on this court through the Court of Appeals. So I'm not denying that. Initially, I was focused entirely or mostly on the Cobb's plea. I believe that in terms of whether this was a valid sentence or not, I believe that the court sentenced in line with that Cobb's plea, that Cobb's agreement. And when you have a Cobb's agreement, the defendant waives any objection to scoring errors, things of that nature, because they get this benefit of the bargain, and that plea. If this court sentenced in accordance with that plea, then that plea should stand, or that sentence should stand. I agree that Hines does stand for the proposition that that automatic doubling of the guidelines is not permitted in terms of how you go about sentencing under when you have a double penalty provision under MCL 333.7413. As I understand it now, the procedure should be that a court decides the minimum sentencing guidelines as they would normally. And then the court, if they choose a minimum sentence within the guidelines, then there's no need for any further explanation. If the court goes outside the guidelines in terms of choosing a minimum sentence, then they need to justify the departure. That's the same in any instance. Then, as I understand, the trial court is to determine whether it wants to double the sentence under MCL's 33.7413. If the court does that, then the court doubles the maximum under that statute. I think this is kind of where the argument kind of splits, is whether if you choose as the sentencing judge to double the maximum, whether it's automatic that the minimum is going to be doubled. I think that's where I'm having an issue here with this particular case, just in light of the Cobb's agreement. The bottom line is when I read the plea agreement as well as the sentencing transcripts, it's my understanding that now the court has to articulate a reason for why it is choosing to impose the double penalty under MCL 33.7413. So if the court decides to do that, they have to put on the record, under Hines, they have to put on the record why it's choosing, and it not just because the defendant has a prior. So that's my understanding of it. Now that after I've wrote my answer, in light of even the maximum in this case, I don't think that there's anything in the record with regard to why the court chose to do the doubling of the maximum. I think it seems to be that it was automatic, and I'm not sure under Hines that would be sufficient. So in light of that, I'm going to obviously leave it in the court's discretion, but my position is somewhat changed just from that standpoint. So I was mostly focusing on the minimum issue and the fact that there was a comps plea, and that he waived any kind of argument there on what that minimum could be, and then the court sentenced him to that 25 minimum cap. There's nothing in the record that I saw that at time of the plea that the 25 minimum cap was put out there or agreed to because of this doubling of the guidelines. There's nothing in the record that I saw that says that. So again, my argument was that, you sentenced within the plea agreement. Again, Hines being a relatively new decision, and in Hines, the Court of Appeals said that the trial court had put enough on the record to justify why it doubled the max. And I think you did put on provisions in the sentencing about why you were sentencing the way you were going to, but I think that was in reference to the minimum. I don't think that there's anything in the record with regard to the maximum. So I guess that's all I will say at this point, and leave it in the court's discretion, but I happy to answer any other questions.
Okay. I do think that Mr. Jones is entitled to sentencing in light of the Hines case. The court did sentence Mr. Jones to 25 to 480 months under the belief that the guidelines were as calculated in the pre-sentence report, 20 to 46 months. I think People versus Hines makes it clear that was incorrect because the statute post Lockridge now has no effect on the minimum guidelines, and so the court had an incorrect understanding of what the minimum guidelines were in setting Mr. Jones' sentence. So does have the right to be sentenced on the basis of accurate information. That did not occur here, and so I would agree to grant the motion and agree that he is entitled to resentencing. So we would then need to set a date for resentencing, and my next available sentencing date right now is August 29th, 8:15 a.m.
Thank you, Your Honor.
That works.
That works for us.
Just one moment, Your Honor. I think that works, but let me double check.
Your Honor, I've also prepared just a basic order, if you wouldn't mind signing. I'll show the prosecutor as well.
That makes sense. Do a notice.
Right, just
Okay.
for the court.
Okay.
That's fine. Thank you.
Oh, do you want me to?
Oh, yes, that's great.
Yeah, approach it.
Sure.
Hey, Judge, could you put that a resentencing on August 28th?
The 28th is full, so the next date we would be looking at is September 4th.
Unfortunately, that date wouldn't work for us. I have to be up north for a hearing.
Okay. So the next available date would be September 18th.
That works. That's fine.
Okay, so September 18th at 8:15. And I have signed that. Anything else we need to address today?
I think maybe just in light of the guideline issue, probably an updated PSI needs to be prepared prior. Because that would, I think it's referenced in there, the doubling of the guidelines, so.
Your Honor, we don't object. We just ask that attorney be present for that interview.
I will, we'll make a note of that and send that request to the probation department.
Thank you very much. Do you mind if I come grab the order?
And then, Your Honor, one more thing, just, are we doing it in person or by Zoom? Just for writ purposes.
The PSIR interview?
Oh, no,
sentence.
oh, we'd like to be in person. Okay, Your Honor.
So we'll do that in person.
Yes.
All right, anything else for today?
No.
So that order, are you gonna file that with the clerk's office or what do we?
Yes.
Okay.
That was my plan. Is there?
I can just put it in the file and we send the file over.
Okay, I just, let me, we have to take a copy of it for our purposes, so let me do that really quick.
That's fine. Whichever way you want to do it's fine.
Yep. I will scan it on my phone. Thank you.
Okay, I think we're all set.
Thank you.
Thank you very much.
Thank you very much.
All right, Mr. Fry, are you ready to proceed with Mr. Gold's case?
Yes.
Yeah. Response. Okay, and Ms. McClure, are you there? Okay,
And
so
Judge,
this- yeah.
sorry, Judge, I just want to let you know, I asked Detective Putnam to join us for this just because he has a little bit more information about the case.
Okay, so this is file 24-21915-FH, 24-21916-FH, and 25-22117-FC. We are here today for a hearing regarding Mr. Goebel's bond situation. The court was contacted by the Lenawee County Jail this morning, indicating that they had to take Mr. Goebel to the hospital. I don't know if it was yesterday or today, but it was recent. The long and the short of it is he is having to have a surgery today and will be kept overnight tonight. And there was some concern about the jail's ability to provide the level of care he's going to need once he is released. And So I think in light of that, I wanted to have a discussion about bond and what would be appropriate as a response to the situation that has arisen. I don't know how much any of you knew about any of that before logging in today. So I guess let me start with Ms. McClure. Do you have any immediate thoughts on how to go forward with this?
I mean, my immediate thoughts are, we don't necessarily want someone from the jail to have to sit at the hospital with him. And I know that's a concern for the jail, but both Detective Putnam and I are strongly opposed to any sort of release following that. We do believe he should return to the jail upon completion of his treatment. It's just semantics. Like, we can get into the content of the case and stuff further, but I won't at this moment. I just know those are my initial thoughts.
All right, Mr. Fry.
Yeah, Your Honor. So I actually did go to the jail to visit Mr. Goebel yesterday and was told that he wasn't there and was getting a procedure done, but I hadn't heard from him or his family about that or what exactly was going on until today. Obviously when the court was contacted to, about the seriousness of the issues that he had going on. So I haven't talked to my client about this. Sounds like he probably isn't in a condition to do much right now. I'm not sure. I haven't talked to the jail either. So, it sounds like the jail is reaching out because they don't think that they're going to be able to supervise him, or he wouldn't be able to go back to the jail after the procedure, I guess. But I don't have any personal knowledge of what's actually going on here. If the jail can't supervise him, I mean, it would make sense to put him on some type of tether or something so the court could supervise him in the community and he can get the medical treatment he needs. But again, I don't have very much information about what's going on. All I know is that yesterday he was taken by the jail for some type of procedure, and today it sounds like it's more serious than everyone thought.
All right, it would obviously be helpful for me to know something more about his medical situation. If we were to set this over and have a hearing maybe tomorrow morning at 8 a.m., Mr. Fry, would that give you time to try to get in contact with him?
I don't even know where he's at right now. I don't know if someone else knows.
I assume you can find out.
I can try to get a hold of his family and maybe they can give me that information, but I can try.
Okay.
I would assume the jail would know where he is.
I believe
Yeah,
the jail said that he was at St. Joe's Hospital.
Okay, I made the mistaken presumption that you'd be here at the Pro Medical Hospital, but that's obviously.
Judge, I've been communicating with Lieutenant Barrios. I'm sure that she could call in to provide an update because she has been communicating with the hospital this morning.
Okay.
Is his procedure today, or is that what we had heard?
I think it's happening as we speak, or.
So then maybe tomorrow would be better and we can get an update from the hospital on how he's doing and what his care is going to look like after that. Because if he's going to go in some sort of care facility, that's something we wouldn't be opposed to because he's going to have some sort of supervision while there. But if he's going to go back home, obviously we would object to that.
So, Mr. Fry, are you available at 8 a.m. tomorrow morning?
Yeah, I can do that, Your Honor.
And Ms. McClure, are you available?
I am.
All right, why don't we do that and hopefully at that point have some more accurate information, more developed information about what his medical status is, and put me in a better decision to make a good decision. All right, well, thank you for your time and for dropping everything and jumping on or coming up here. So I appreciate that. And see you tomorrow.
Thank you. Yeah,
Thank you.
thank you for notifying us.